Welcome to today's China-Australia Topics podcast called Responsibility in Disguise, Nominalization,
名词化
and the Language of Law. We'll look at the world of legal language, not the courtroom drama of witnesses and lawyers, but rather the hidden mechanics of words themselves. Our guide is a 2025 study by Professor Wei Yongqian,
魏永熙
titled An Analysis of Responsibility Evasion in Anglo-American Legal Discourse from the Perspective of Nominalization.
名词化视角下英美法系话语中的责任规避判析。
Now, if that sounds technical, don't worry, we'll break it down step by step, with examples, stories, and, because this is a bilingual exploration, we'll bring in key Chinese concepts to illuminate the analysis. At the heart of this discussion is one powerful linguistic device, nominalization.
名词化
This is when we take an action, like prosecute, and turn it into a noun, prosecution. It seems simple, but in legal texts, this shift does more than change grammar. It can obscure who is responsible, transfer agency to the institution, and ultimately reshape how law functions in society. By the end of today's episode, I'll ask you to reflect, what does it mean for the conduct of law in the West when responsibility is hidden deep in language itself? What is nominalization?
名词化
Let's begin with the basics. Nominalization
名词化
literally means making something into a noun. It's a core part of what linguist Halliday called
语法隐喻
grammatical metaphor. For example, instead of saying, the government regulates trade, the legal text might say, regulation of trade shall be applied. See the shift? The action regulates becomes a noun regulation, and more importantly, the actor, the government, disappears. This is what scholars call de-agentization.
去行为者化
The action happens, the law is in motion, but we no longer know who is acting. Legal language is filled with these transformations. Why? Because law seeks to appear objective, timeless, and above human conflict. By removing the messy reality of actors, the text gains authority, and this isn't unique to English. In Chinese law, we see similar patterns. For instance, responsibility shall be borne.
应当承担责任
Again, who bears it? The text doesn't say. Responsibility just floats in the air, having been institutionalized. So nominalization isn't just grammar, it's power, and that's where Michel Foucault
福柯
comes in. Foucault
福柯
and the disappearance of actors. Michel Foucault argued that institutions speak with a voice that hides individuals. In law, this voice is constructed through devices like nominalization. Take this example from the Civil Rights Act in the United States. Liability shall be incurred in cases of breach. Here, the key word is liability.
责任
But who incurs it? The sentence doesn't tell us. It's framed as if liability emerges naturally from the system itself. This is classic responsibility evasion.
责任规避
The legal system avoids naming the responsible party. Instead, responsibility is absorbed into the structure, into the woodwork, making it harder to directly challenge your contest. Foucault would say this creates a system where power operates invisibly. Law appears neutral, objective, and inevitable. However, in reality, it is shaped by choices, actors, and politics. Findings: the words that disguise responsibility. Professor Wei's study analyzed 6 key Anglo-American texts. 1. U.S. Constitution. 2. The Bill of Rights. 3. The Declaration of Independence. 4. The Civil Rights Act. 5. The UK Parliament Acts. And 6. The Human Rights Act. The study identified a set of high-frequency nominalizations. Let me share a few. Regulation.
规章
134 times prosecution.
起诉
98 times government.
政府
110 times agreement.
协议
75 times responsibility.
责任
83 times legality.
合法性
57 times fairness.
公平性
42 times. Notice something? These aren't people. They're abstractions. A clause like this regulation shall be enforced suggests the regulation enforces itself. there's no enforcer in sight. Similarly, responsibilities shall be defined in accordance with procedures makes responsibility seem like a neutral object, rather than the outcome of human negotiation. This is how grammar
语法
works as a political tool.
政治工具
Western law in practice, corporate and AI responsibility. Now let's step outside the historical texts and look at how this plays out in today's Western legal systems. Think of a corporate scandal. The press release often says, mistakes were made. Notice the passive structure. No one admits fault. In corporate law, responsibility often gets framed abstractly. Compliance was not achieved, or oversight failed. The agent is gone. The system talks about itself. In AI governance, we hear phrases like accountability mechanisms will be ensured. Again, who ensures them? Which company? Which developer? The language doesn't say. Responsibility becomes a ghost. International law too is filled with such evasions. Treaties speak of violations shall be addressed, but don't always specify by whom. In all of these cases, nominalism
名词化
creates a veil, turning accountability into abstraction. Why it matters. Implications for law in the West. Why should we care about this? Because legal discourse
法律话语
shapes not just law, but justice itself. When responsibility is hidden behind abstract nouns,
抽象名词
citizens may struggle to demand accountability. Institutions appear neutral, but in reality, choices are being made by people, lawmakers, corporations, judges. Citizens may struggle to demand accountability. Institutions appear neutral, but in reality, choices are being made by people, lawmakers, corporations, judges. This has three major implications for Western law. Democratic transparency. If laws and judgments rely on nominalizations, citizens lose sight of who is responsible. This weakens democratic oversight. Corporate accountability. Companies can use nominalization strategically. Regulation was breached instead of we breached regulation. This diffuses blame. Emerging technologies. In fields like AI or biotechnology, responsibility might vanish into phrases like risks will be managed. But who manages them? Without clarity, accountability is lost. Toward linguistic awareness in law. So, what have we learned today? That the small shift from verbs to nouns, nominalization,
名词化
can profoundly reshape legal meaning. It abstracts actions, erases actors, and blurs responsibility. That de-agentization
去行为者化
isn't just a linguistic trick, it's a political and institutional strategy. And that in the West, as much as in China, law's authority depends not just on what it says, but how it says it. The challenge for us is to read legal texts critically, to ask, who is hidden in these words? Whose responsibility is being disguised? Because justice, in the end, requires not only fairness and legality,
公平性
and,
合法性
but also honesty and language. Thank you for joining me on this exploration of law and language. Stay connected.